If going into the pandemic, this was bothering you and you got a little bit relief from it by not having to be faced with it every day, and now you're getting faced with it again, pay attention to that gut. If it's bothering you, then it's time to say something and it's time to do something.
Corporate fraud works best in the shadows, behind corporate walls. How does the government bring these wrongdoers to justice? Whistleblowers. These are the stories of those who risk their careers to shine a light on allegations of fraud. Today on Fraud in America.
On today's episode of Fraud in America, we're going to go in a little bit of a different direction by looking at the False Claims Act, the primary weapon against fraud on the government. This law that dates back to Abraham Lincoln is the primary means by which whistleblowers go after the corporate giants that are committing fraud in our country. This law incentivizes private citizens to step forward and bring cases on behalf of the federal government against companies and individuals that are defrauding government programs. If the case is successful, whistleblowers, or as we call them, relators, receive a percentage of the money collected by the government. The False Claims Act has many different wrinkles and nuances, and we're going to cover some of those today with my special guest, the executive producer of this show. Her name is Kate Scanlan. She's a longtime whistleblower attorney and a very dear friend who is very knowledgeable about this practice area. So we're going to cover a lot of the questions that potential whistleblowers have or should have as they're thinking about stepping forward, the questions that we oftentimes receive as whistleblower attorneys, so that potential whistleblowers can think through the answers to these questions before they think about picking up the phone and calling a whistleblower attorney. All of that happens today on this episode of Fraud in America. Well, I appreciate, Kate, you joining us. As I said in the intro, you've had an impressive career dating back many, many years. And of course, you're now full-fledged into the TAF world as chair of our public education committee and have played an instrumental role as our executive director, executive producer of this show. So I thought it was important for us to get together. I was trying to think of somebody I could jump on to basically walk potential whistleblowers through all the thought processes that they tend to go through when it comes to bringing a case. We've gone through, this will be our 10th episode. We've had high-ranking government people, we've had whistleblowers, we've had relators counsel, but this will be our first kind of dive into kind of the nuts and bolts of what a potential relator should think about, what they should do when they think about stepping forward and making that courageous decision to become a whistleblower. So I appreciate you joining me. You're a good friend of mine. So this is, I know, going to be a lot of fun and hopefully educational for folks that are joining us on today's show. Kate, thanks for joining me.
Well, thank you, Jeb. It's an honor to be here, really. I want to also welcome any potential whistleblowers. I know that my introduction to TAF many years ago now, I felt like I found my people the first time that I was surrounded by the TAF lawyers and meeting some of the former whistleblowers that were at the first conference that I went to. And your idea to do this podcast to provide that kind of resource to potential whistleblowers, I really hope that people find that same kind of warm welcome here at Fraud in America and at TAF, that they can learn and find some important information that helps them in their decision making as they go forward, grappling with what we both know is an incredibly challenging and difficult decision for somebody who makes a decision to come forward.
So, Kate, there's I know a lot of things about you, but two things I want to make sure people know about. One, and I find this impressive because I've seen how far this is, and I know how cold 58 degrees is, but you swam successfully the Escape from Alcatraz swim in 58-degree water temperature without a wetsuit. That's pretty impressive. I know that didn't go well for a lot of prisoners escaping Alcatraz. That's very impressive.
You have fact checked this correctly. I did do it. I did it without a wetsuit. And the only bragging right that I will have was that I had decided that I wanted to be able to do it in, I think I set my time frame as 45 minutes to an hour was kind of what I wanted to do. And I got to the end of the swim and I had done it in 46 minutes. And I was like, oh, I totally could have done it under 45. So that tells you a little bit about my personality, I think. But it was great
Amen.
fun and it was a great accomplishment. And, it's a great talking point.
Yeah, that's great. That's great. Don't recommend that one, but that's good. That's very good. So you're one of 7 children. That explains why you're able to herd all of the cats that are a part of this show. Can you talk a little bit about where you grew up, why you decided to become a whistleblower attorney?
Yeah. So also true. I grew up in Rhode Island. I am the sixth of 7 children. And I have my sister is the eldest, and then it's me and 5 boys. So my sister went to college when I was about 9, so she left me with a house full of 5 brothers, which is always the topic of a lot of conversation amongst all of us. And it was great fun. We grew up in a place where there were lots of outdoor activities to do, lots of outdoor swimming, um, and my parents were both. Firmly committed to education. That was something they were strongly supportive of, and our whole family focus was definitely surrounded towards education and making sure you learned and learned well. And they were also very, very strongly encouraging to all of us to always do the right thing. And we learned those lessons as a family early on. And we got supported by one another in doing it. So even when times were tough, you kind of had your siblings out there who were able to be your posse with you. And so you learned to scrap amongst yourselves and then put a united front out to the world at large. And I think that's partly where I learned the skill set that I carry with me now. I put up the fight when I have to.
That's great. That's great. I had heard recently this quote that when you're lost, you should pull out your compass. And when you're ethically lost, you want to make sure it's a moral compass. And I hear so many stories on the show and over the years talking potential and whistleblowers that moral compass was established in their childhood. That's very consistent from what we've heard from so many people, whistleblowers and whistleblower attorneys alike. So I appreciate you sharing that.
Yeah, of course.
Let's talk a little bit about um, kind of how people go about contacting a lawyer. What are some of the things people should think about when they do this? I did some math going into this. This is my 7,173rd day being involved in whistleblower on the whistleblower front, 7,173 days. So
Wow.
I've probably talked to 7,143 potential whistleblowers.
Yeah.
And it's always this initial conversation where people are not quite sure how to contact a lawyer, what they should say, what they should do. You have thoughts on that, Kate?
Yeah, in this age of the internet, there's so many different ways to reach out. I mean, we put in the show notes for Fraud in America, we put in the link to the website and the link to TAF and the member directory. And all of our members, and my firm included, we all maintain our own websites where you can, send an email to somebody to ask for it. And you can also pick up the phone and call a firm and ask to speak to somebody. There's really no right way to do this. And I don't know about you, Jeb, but the thing that I notice too is that sometimes the client intake that you first get, sometimes it's coming in after hours. It's on the weekend. It's in the middle of the night. These are people who are having to make difficult choices, and they're certainly not doing it in the middle of their workday. They're not calling people 9 to 5 because that's when they happen to be at the job where they're seeing whatever the fraud is that's going on in so many circumstances. So there isn't a particular right way to do it. I think the only real recommendation I have is make sure you're comfortable with what you're doing. Don't ever put yourself in a situation where you're picking up the phone and you're not ready to talk to somebody. That's first and foremost.
Yeah, such an interesting time in our world's history right now, right? This pandemic has, I think, forced a lot of people to look at their priorities, sometimes reprioritize. And I know a lot of people right now are thinking about, going back to a workplace where they don't feel comfortable. They know there's some fraud happening, maybe patient harm is happening, and the company is telling them to look the other way. What would you say to that person right now?
I think I would say pay attention to your gut. If going into the pandemic, this was bothering you and you got a little bit relief from it by not having to be faced with it every day, and now you're getting faced with it again, pay attention to that gut. If it's bothering you, then it's time to say something and it's time to do something. And the other part that I would also say is, you know, we also don't know what COVID has done to create potential new frauds. There's so much new money that the federal government has put into our economy in order to help keep us moving during the pandemic that you could return to a job and find something that you didn't see happening before that suddenly is happening. And we're collectively as a society deciding what we're going to look like at the other side of the pandemic. If you see something that doesn't look right to you, do something. We'll help walk you through it. It doesn't necessarily mean you have to become a whistleblower and file a case, but get some information, figure out what you can do with what you know.
They contact your firm, and your firm does what's called a conflicts check. What is that?
Yeah, this is an important first step that a lot of folks don't necessarily realize. So, as a lawyer, any lawyer, no matter where you are in the country, you have an obligation and a duty to represent your client, and to do it, it's a duty of loyalty first and foremost, so that everything that you do is in loyalty to that client. So, if you contact me and I already am representing somebody whose information is in conflict with you, it is not fair to you and it is not fair to the client that I already represent for me to take in information from you and to present that kind of front where my loyalties are then divided. So the first thing that you want to do as a potential whistleblower is to not tell your story right away, but to say, here's my name, here's the potential defendant that I'm going to tell you about. Do you have any conflict with hearing my story? And that's the important question. Is there a conflict for you to hear my story about defendant XYZ? That's going to allow that lawyer to say, oh, wait a minute, hold the phone. And if you call somebody, like if somebody called me and I had a conflict like that, I would say it right out of the gate. I would say, stop, don't tell me the details. But here's the thing. I know this great guy named Jeb, and I'm going to give you Jeb's phone number, and Jeb's going to hook you up with either a lawyer that he knows is not conflicted, or he's going to give you an entire list of lawyers that you can contact to make sure that you can talk to somebody who will be as loyal to you as I am to the client that I already have.
Such a huge point. Another point that I oftentimes made right out of the bat was this, stressing the importance of the attorney-client privilege. That in other areas of the law, people come home and they talk about their job and they talk about their clients and their struggles, and because of the attorney-client privilege, we kind of live a life in a bubble, right? We simply can't talk about so much that we know. Can you talk about what that privilege is? Why is that so important?
We sure do. We live in that little bubble. So the first thing for a potential whistleblower to realize is when you call that lawyer for that first intake, you don't necessarily have an attorney-client relationship. The lawyer's not agreeing to take you on as a client. But calling a lawyer seeking legal advice surrounds that communication with privilege, with confidentiality. So you are allowed to presume that communication is going to be confidential. And that's so important for the potential whistleblower because they don't know who to trust. I can't tell you how many times, I'm sure you have stories with this, with folks who, they're looking over their shoulder, wondering at every turn, if somebody is on their side or against their side. So to come into a situation where the person says right out of the gate, what you're saying to me is confidential, I can't even go home and tell my husband or my wife or, or any of my work colleagues, what you just told me. It's in the vault. That creates that critical relationship of trust that then becomes the foundation of what becomes in our world a fairly long-term relationship. Some of these cases can go on for years. So that first communication where that potential client learns to trust that the lawyer's communications are confidential is really critical.
You just hit on a really big point. Yeah, some of these cases do last years. Some of them have lasted over 10 years, right? So that
Yes,
lasts longer
indeed.
than some marriages, right?
Yep,
So it is
indeed.
a marriage, it's a relationship. Having that relationship be strong and one that you trust, and knowing that this is an attorney that you can get along with, and there's a level of trust and rapport is so important. From your side, what are you looking for in the client?
Honesty. I think if you talk to anyone who's a member of our bar, you know, we take dozens of intakes, and one of my friends and mentors in this arrangement has said, takes 100 calls to actually get the one who actually has a case. It's not to say that the other people are not reporting fraud, but it's challenging. It's tough to find the set of facts that is worth the risk for that client to go forward with things. A lot of times we end up doing things other than having them bring a case with whatever the information is. So I think that is the critical first step, to make sure that they're honest about what they're doing. I think another really important part of this is whistleblowers get a really bad rap, and they get labeled as snitches. They get labeled for coming in only looking for the money in all of this. So the thing that I'm looking for right out of the gate is, what's at stake for you? Why are you doing this? What's at risk if you do it? And have you really thought through what the implications are of this? I have been executive producing this with you, so I've been listening to our interviews with some of our past guests, and Ellen and Cheryl, and you listen to the thoughtful deliberation and the angst and the turmoil that they went through before they ever picked up the phone to call Marlon or to call Leslie. And I know Leslie and I know Marlon, and I can just imagine those first calls. And that's what you're looking for. You're looking for that person who has thought through and isn't doing something on an impulse, and is willing to consider the implications of what they have as information, and to know that this is going to be potentially a really difficult road.
Mm. When assessing cases, in addition to assessing, is this the right attorney-client relationship? Understanding that case, recognizing, and we've talked about this on other shows. That the government has limited resources, despite what you might hear. They only do intervene in a certain percentage of them. So for us to advise a client to say, you know what, this is the right vehicle for you. You should indeed step forward. I'm going to represent you in this matter. There's a level of certainty that we need to have, right? That the government is going to take this case seriously, and this is a case that will hold up in court. What are some of the calculus that you go through in assessing the actual case itself? What are the things you're looking for?
Yeah, that's such a great question, Jeb, because I've done so many intakes where, potential clients, they feel like I'm putting them through the ringer. And some of it is, we're all, in our personal lives, we're affable, and, we can joke around, but it's almost like when that potential client calls up, that we go into full-blown lawyer mode. And the analytical skills come out, and it's all business. And so what am I looking for? There's a couple of things. One, a fraud on the government is a fraud, which means that if we're going to do this as a legal case, we have to have evidence of the fraud, not just a little bit of smoke around the edges. We need to be able to see some actual fire. And that fire is oftentimes in the form of different kinds of evidence. Sometimes it's documents, sometimes it's having been a participant in a particular meeting or a voicemail or a text message. There's all different kinds of evidence. So that's one of the things that I'm evaluating is what does this person have within their own personal knowledge? What have they actually seen and observed in the job? And the other question is where, if this is a massive government contractor, where in that entity does this whistleblower live in their day-to-day job? And whistleblowers can come from all different places. I don't want to imply that there's only one category of employee that can be a whistleblower, because that is so far from the truth. I mean, we've seen cases where patients have been the ones who came forward and were able to demonstrate that there was a fraud in a healthcare program based on the care that they were given. So I don't want to suggest that that's not that there's only one way to do this, but we do evaluate, from and I know you have, you're going to help me with whatever this view is, but if we're all looking at the same elephant, everybody looks at it from a slightly different perspective. So that's one of the things that we're looking at is where are you sitting and how do you see the elephant from where you're sitting?
That's a great point. A lot of times people come in and they're pointing to something and they're describing what you would describe as the trunk of the elephant. But in reality, it's a snake, right? They just don't realize that the rest of it is fine. And sometimes that's just the reality is once you dig into it, there is no there. One of the things I always encourage our members, and certainly would encourage potential whistleblowers, is to try to distill all of their allegations and facts down to, I look for a one pager. I know you call it an elevator pitch. Try to make it simple to understand. We're not looking for war and peace. We're not looking for things scanned in by blind monkeys. Like, try to really make it simple to understand, because complexity doesn't lead to execution, right? So like trying to really distill down your thinking of what the case is about to something that's really manageable. Is that right for you too, Kate?
100% agree. And I call it an elevator pitch because, in this day and age where, we field cases or potential cases from all around the country. So, my initial contact with a potential client is oftentimes by the phone. I'm not going to go, fly to another, especially during COVID, I'm not going to go to another part of the country. That happens over the phone. And so, my first question always is, just tell me why you called. Tell me what brought you to want to pick up the phone to talk to me. And so that 30-second elevator pitch is your answer to that open-ended question of what's bringing you here. And it's just enough to make sure that the person is comfortable and confident in being able to articulate something, because I guarantee you're not going to make it to the end of that 30-second spiel before I'm going to interject and ask you a question. Well, wait a minute, hold on, back it up, tell me this. But if the person has that prepared, it's like a building block. It's the solid foundation. You start with that, and then you're ready to answer any questions when somebody jumps in. And they can always go back to it. Anything that was in that pitch, if I interrupt you and you don't get to say it, you get to go back and be like, well, wait a minute, I was getting there. I was going to say that to you, but you interrupted me. So having that kind of foundation just makes you that much more confident going into that first conversation.
So we spent some time talking about how we choose cases. The flip side, of course, is that potential whistleblowers need to choose a lawyer, and this is a topic that's of passion of mine. As president of Taxpayers Against Fraud, the education fund, I have a duty of loyalty to all 500 of our attorneys. I don't recommend or refer out to individual attorneys. We have a membership directory that lists all of our members. But some of the things I do encourage potential whistleblowers to do is to do their homework. And if you look at the directory, it leads, of course, to websites. And on the websites, you'll see the success that attorney may have had, the similar cases, whether or not they have cases in the past that are similar to your allegations, where they are located. All these things are kind of really spelled out. Thank goodness to Al Gore and the invention of the internet. It's all available for people to do their homework on. But one of the things we always do is, do your homework. look and see what's out there, see what's the right match for you, and then call them, right? Pick up the
Yep.
phone, talk to that person, and see if that person is indeed a good match for you. You have anything on that, Kate?
I do, and I go back to what I said a while ago on one of those other questions that you asked me. Trust your gut. You know, this is a relationship that you're going to be forging, and it may last for a long time. You know, evaluate it the same way you evaluate any other relationship that you have. And do you feel safe? Does the person answer your questions? Do you feel comfortable? And that's first and foremost. For me, it doesn't matter whether that person is in Seattle or San Diego, Omaha, Nebraska, Chicago, Miami. They could be wherever. And if that's the person that you connect with, that should be the person that you choose as your lawyer. And so trust your gut on that part of it. The other part, there was a really interesting, Ellen made a point in her interview on Fraud in America that she was dealing with a case that was, focused in Florida. And she was reluctant to choose a Florida lawyer because she was worried about, it becoming a matter of local knowledge. So she chose somebody like Marlon, who was close nearby, but was not part of that Florida scene. So that to me is such a valuable insight that says, if you're working, in New York, you don't have to have a New York lawyer representing you. If you're here in San Francisco, but you feel like you want a lawyer from LA, you can make that happen too. It's part of the beauty of the internet and the age of air travel and everything else. Lawyers will come to you, that you don't necessarily have to have somebody that, that you can go and meet in person that first time.
So a big point that we oftentimes hear is, I didn't step forward because I couldn't afford a lawyer. And this is one of these primary reasons why we started this show, is to make sure that all the misunderstandings and myths and misconceptions out there are attacked head on. And this one about not having money to hire an attorney is one I love for people to really focus in on. If your attorney that you go to is sticking you with a bill straight out of the gate, you may want to keep calling. One of the things we strongly encourage our members to do is to follow what the False Claims Act says, which is that the defendant should be paying the attorney fees. And of course, at the end of the day, our attorneys tend to get a percentage of the recovery that they get for the government and the relator. But those fees, those attorneys' fees, are typically paid for by the defendant. So the out-of-pocket expenses for potential relators tends to be very, very close to zero. Is that true for you too, Kate?
It is. And, it's such an important message. And the mechanism that we use, and it's the only time I'm going to try to use a legal terminology here in our discussion, is these are referred to as contingent fee arrangements. And so what my firm does, and what I know most of the firms that I have high regard for in the whistleblower bar, we don't get paid unless we are successful. We defer all of our fees until the point in time that we have a successful recovery, at which point in time we make a request of the defendant to pay those fees as is permitted under the law. So these cases that go on for years, the lawyers are taking the weight of that on themselves, and the client does not bear the burden of those fees. You don't see my billable rate hourly as I'm going forward to work on your case. That will all get done afterwards. And the other part of that is part of that contingency is also a percentage of whatever the relator's recovery might be. That's a very standard relationship. It's not controversial, and it's well accepted by the courts. I know a lot of defendants like to make hay out of that and suggest that these are cases that are driven for bad reasons. But if you think about it, the benefit that potential relator gets by having those lawyers spend years working for them is so invaluable, especially when you juxtapose it against the defendant, who is able to afford to pay high priced lawyers and to keep them on retainer and to pay them regularly. So this is a mechanism that allows that Davy versus Goliath evening of the playing field, and to let that relator and that potential whistleblower have the benefit of really competent counsel without having to pay millions of dollars out of their own pocket.
So we talked about the limited resources of the government, and because there's limited resources, they're oftentimes looking for low-hanging fruit, or ideally boxed fruit, which means we need to come to them with a box of evidence, which is one of my favorite topics. So when you're looking for evidence, like what kind of evidence are you looking for from this potential whistleblower?
So evidence takes a number of forms. There's no single way to describe what evidence is. I think we think of this as, the smoking gun document, but the reality is that most cases are not built on a smoking gun document. They're built on, a box or two boxes of documents that you put email one together with email number two, together with the spreadsheet that demonstrates, the overpricing of a particular product or whatever that example might be. And I mentioned this earlier that, it's access. Have you been in a meeting? Do you have an agenda from in a meeting where a certain issue was being described? If you're a sales representative, do you have marketing materials? Do you have things where you have been trained to address a topic in a certain way? In a defense contractor case, do you have examples of inspection reports or audits that suggest that something is being done that isn't consistent? There are as many different kinds of evidence as there are cases and frauds against the government. And one of the things that I also think is important in this context is we as lawyers, you could call me up with, a fraud involving, I'm going to just randomly do something, the Department of Agriculture with a school lunch program. You are going to know more about the Department of Agriculture and the school lunch program than I am in that first couple of calls. I'll eventually catch up to you, but at least out of the gate, you're the expert. You're the one who's going to be directing me on what your evidence is. And then as we go along, we might flesh that out. But I think it's important for that potential whistleblower to understand and be empowered to know, here's what I've gotten. I'm going to educate you on what the evidence is.
The one area that always leads to a lot of discussion from our side, and certainly catches the alarm bells over at the Justice Department, involves attorney-client privilege documents. What does that mean, and why is that such a concern?
Third rail, right? That's the little hot
Yes,
wire.
amen.
Enough to draw the blood from the face of any lawyer, where you look at it and you're like, uh-oh. But it's not as bad as it sounds. So we talked about this duty of loyalty earlier. So the same thing is going to hold true for the defendant who may be committing a fraud. So those defendants have lawyers inevitably. And so if the potential whistleblower in the context of their job has any communications with the lawyers, those communications as an employee of the defendant or being in possession of any of that defendant communication, they can't turn that over to me, and they can't turn it over to the government. Those privileged communications belong to the defendant, and we have to steer clear of those. We can't touch those. So one of the things that we do right out of the gate when we're talking about evidence and documents, one of my first questions is always, in the course of your job, do you have any communications with the lawyers? Who are the lawyers? What are their names? So that we can flag that right out of the gate and make sure that if something comes across inadvertently, that we can flag it and set aside and be like, I'm not looking at anybody's confidential documents. And the way that I look at that is it's kind of like the golden rule: do unto others as you would do unto yourself. And, you wouldn't want your communications with me to get turned over. So we're going to take that same position with any communications that belong to the defendant. We may fight them down the road and say, you're not entitled to keep those privileged because you are committing a fraud. But at least out of the gate, we're going to say, you're entitled to not have me look at those and not have the government look at them.
So 80% of all recoveries are brought under the healthcare arena, a lot of healthcare cases, which of course oftentimes raises questions about HIPAA. My wife is a physician, and I always hear about HIPAA all day long from her. So what does HIPAA say about these documents, patient files, things like that?
Yeah, so HIPAA is I'm going to get it completely wrong, but it's, the Health Insurance Portability Accountability Act, something. Well, we all just
Yeah.
refer to it as HIPAA, and anybody in healthcare knows about HIPAA, like you're describing. It basically is a mechanism that gives greater protection to a patient not to have their healthcare information blasted out across the stratosphere. So, a lot of times in healthcare cases, the potential whistleblower has evidence that is in the form of patient records. And you were talking about, what form does evidence take? It's mistreatment to a patient, overcharge for a certain procedure, whatever. So, what the law provides with HIPAA is that even though that patient is entitled to protection of that health record to keep it from becoming public, you as a potential whistleblower are allowed to bring that record to the government and to show them in the context of investigating a fraud. There's an exception to HIPAA, is basically what it amounts to. And it's only for purposes of bringing it to the government. It's not to put it in your complaint. It's not to put it in a press release. So you still treat that patient's information as confidential. So if you referenced it in your complaint, you might say patient number one instead of saying John Smith, who lives at 457 High Street. You just refer to them anonymously, but it allows you to be able to bring your actual evidence of the fraud to the government.
So one area that I've seen the biggest change over the last 20 years involves the internet, and certainly the emergence of social media has become a double-edged sword in our world. Just to slightly tiptoe into one of the nuances of the False Claims Act, there's what's called the public disclosure bar, which basically says you can't take what's out in the public domain, piece it together from like a newspaper article and turn it into a case. So setting that issue aside, how has social media and the internet impacted what we do in our world?
It's led to a lot of complicated scenarios as we
Yeah.
try to analyze what to do with social media. And it's on a number of fronts. It's both a source of evidence. People chat in chat rooms or on Facebook, and they post things on walls where they make admissions that are relevant, that are useful for the government. But they also can be the sources of leaks. Things can get said inadvertently in an environment where we're asking things to be kept confidential. So they're challenging. And I've even heard scenarios with, people who are on LinkedIn and their lawyers are on LinkedIn. And so they friend or they basically make a connection with their whistleblower lawyer on their LinkedIn profile, which is not ideal because then everybody else sees that they're connected to a whistleblower lawyer and wants to know why. I think you have a story about that, don't you? You have an anecdote that relates to LinkedIn connections to whistleblower lawyers.
Yeah.
So social media creates all kinds of ripple effects in every which way. We could probably spend an entire podcast talking about the implications of social media on whistleblower cases. So my preference right out of the gate is I always ask my potential clients, what social media do you use? And, and how do you use it? And then we put guidelines and guardrails around all of it from the very first minute. And part of that is important because you also don't want to shut it down completely. If you have a potential client who, is an influencer on social media and suddenly takes down their entire profile, that sends out an alarm bell, right? So what we're trying to do is not do anything that creates any kind of red flag, but also create an environment where we're able to control what might happen in that social media environment so that we don't, create headaches down the road.
So a lot of this stems from the seal provisions. This is a court order, right? The court saying you cannot talk about that you filed a case against this defendant until this seal is lifted, and that leads to a lot of sleepless nights for us as attorneys, worrying about our attorneys violating this seal provision. So, what is happening while this case is under seal? We talk about this under seal period. What's happening during that time?
So I'm going to go back on my earlier agreement not to talk about legalese. So we're going to talk about legalese. So,
Yes.
in an ordinary lawsuit, when the complaint gets filed, you serve the defendant and everybody knows what the allegations are. But in the False Claims Act, the whistleblower is acting on behalf of the government. So before that complaint ever gets served to the defendant, the first step that the False Claims Act provides is a little buffer period where the complaint goes to the government to allow the government to investigate your allegations and to see whether they agree with the evidence that you've presented, whether there's any more information they can gather. And that's all done behind the seal, where they don't want to tip off the defendant that there's a case filed against them. So that's why the seal is there. The seal is intended to help protect the government's investigation and to give them as much time as they need to evaluate whether what is said in that complaint is something that they're going to join and intervene and take over, or whether they're going to give the opportunity for the relator to then take it over and proceed without them. Since we do know that so many of these cases, 80% or more, do not get taken over by the government.
And that touches on a recent trend that's a beautiful thing. So the government can take over the case, intervene, and move forward with the relator, or they can say, because of whatever reason, limited time, money, resources, whatever, they will not intervene. And the relator, the whistleblower, and his or her attorney can go forward with the case with the government watching what's happening. But the whistleblower's attorney really does take the primary driver's seat at that point. And the thing that we've seen recently is that a lot of those cases are moving forward to successful conclusion, or the government later is taking another look at the case, re-intervening in the case and settling these cases. And those cases are establishing a lot of the great case law that's leading to subsequent settlements. So what is your thought process about whether or not, once the government says, you know what, we're not going to get involved in your case for whatever reason, what is the thought process that you go through on whether or not to go forward without the government?
Yeah. Before I answer that question, there's one other point that I want to make on what you just said about those non-intervened cases. There's a couple of cases out there where the government has gone on the record to the courts that says that the government's decision not to intervene is not a reflection on the merits of the case. And in some cases, it's actually a reflection on the government's confidence in both the whistleblower and the whistleblower's lawyers to go forward and to do that case without them. Because as we've talked about, this is a situation where we know the government doesn't have all the resources it needs. So if they have confidence in the whistleblower and the whistleblower's lawyer, then they're inviting that part of the process, that part of the legal mechanism to get triggered, which is why it is so exciting to see so many more non-intervened cases go forward, because this group of TAF members largely, is really well prepared to go forward with these non-intervened cases. And so then to answer your question, what are we looking for? It's a full and frank conversation with the government to understand what the basis was for why they declined. There are instances where after the government's investigation, you realize that there just isn't a way, there isn't a path forward. And you might not want to go forward with that case. But in other instances, the government has made the determination that in order to be successful in that case, there's going to need to be a lot of discovery. Discovery takes time, it's expensive, and it requires a lot of legal hours to make it happen. And the government doesn't always have those resources. So if this is just going to be a question of being a discovery intensive case, well, sure, bring it on. We'll take up that fight. And some of it, quite honestly, is the relator, the whistleblower's appetite to go forward with this too. Sometimes that decision only happens after the case has been under seal for several years, and life circumstances have changed. Does the whistleblower have the appetite to go forward? And that's a full and frank conversation. And there's no right answer. It's going to be case specific, and that's where that duty of loyalty to the client is so critical, right? That we do what is in our client's best interest, and our client directs us what they want to do. So we will sit down and we'll have a full and frank conversation that says, here are your choices. This is what we can do. Here's, on road A, we can go this way, or road B, we can go this way. And that takes a while. And sometimes we dismiss cases, and sometimes we go forward and we continue to fight.
One of the really neat things about our community is there's a lot of former whistleblowers, both successful and not, who have come together to support future, current, and past whistleblowers. A lot of them have been interviewed on this show, recognizing that other people are going to go through some of those challenges and obstacles that they went through, and that only someone who's been somewhere can help lead you forward, right? So what happens win, lose, or draw? The case settles, the relator receives a percentage, the case doesn't go forward, or it's dismissed, or whatever happens to the case. What's your recommendation to those whistleblowers after the case is all done?
Gosh, I think is to first of all is to realize how courageous you were to do whatever you did, and to also take comfort in the process. Part of the reason that we work the way that we do is that we empower our clients to understand every step of the way and to know what they're doing, so that when they get to the end of the process, they know they made choices all along the road, and that this next stage, whatever it is at the end of this case, is also their choice. They can go back to the job that they were doing, or the industry, the field that they were in, or they can go become a dog walker, if that's what is of interest to them. They have learned so much in that experience that we will help them navigate into that next phase. And there is going to be a next phase, because there is life after whistleblowing. And I think that's the thing that is so amazing to see in all of your guests that you've interviewed, is to see some of them have gone on pretty much with what they were doing before. Others have taken up, new roles in life and explored new things. And I think that that's the hopeful part of this, right? That there's so much else that can be done once you've finished doing what wasn't a choice for so many of our clients. This isn't something they do by choice. They do it because they feel they have no other alternative. And so once we've helped them run that to ground, it's time to open up the next chapter of your life. Kind of like what everybody's doing right now in the post-pandemic environment, right? Like, what are you going to do after the pandemic? What is your life going to look like? We kind of do that with our whistleblower clients. What do you want your life to look like when you're done?
I believe it, Dr. Mona, the Flint water whistleblower, called it the choiceless choice, right?
That's
To do the right thing. Kate, I just want to acknowledge you for all the hours you've put into keeping this show moving forward. I simply could not have done it without you. I really appreciate your friendship, your guidance, all of your help as we got this thing moving. The primary goal of Fraud in America was to do a better job of telling our stories, to educate potential whistleblowers about this vehicle that's available through different whistleblower statutes. So thank you so much for all of your help on the show.
Thank you, Jeff. And thank you for the being our fearless leader in making this podcast happen, because this is your brainchild.
That's a lot of fun. So next week, we are going to dive further into the whistleblower story on the next episode of Fraud in America.
If you believe you've witnessed fraud against the government at your job or want to learn more about these important laws to combat fraud, visit fraudinamerica.com. On our website, you can find whistleblower lawyers, blogs from these expert attorneys, and more. You can also find a transcript of today's show notes, a way to contact our team, and a way to chip in to make sure we can keep bringing you the latest on fraud. This episode was edited and produced by Rachel Brooks, and our theme music is by Connor Chaos. A big thanks to our staff and researchers of Jeb White, James King, Emma Bass, Jackie DeMar, Kate Scanlan, Brian Markovitz, and Max Boltman. You can learn more about them at fraudinamerica.com/team. Fraud in America is a project of Taxpayers Against Fraud Education Fund.